are very appreciative for the messages, for the subscription, for the likes that you put on our videos. We thank you so much. There is Okelo Marvin. You are in Gulu and your team, Gulu University. We congratulate you upon completing your first year, the whole team in Gulu, and then you are now headed to second year. We congratulate you. Thank you so much, but continue to read hard. Law is about reading. Thank you so much, and for liking our page. Okelo Marvin, Mozaki Sarah, and all the team in Gulu. We thank you so much from Gulu University first year students. You asked for this, and I think you're now happy we have done this. Again, we also want to thank you, the students of IU Islamic University, Namamonde, Deborah, and team. Thank you so much, Semanda, and team Hadija, and everybody that watches all this from IU. We congratulate you upon finishing your first year, and now you're headed to second year. Thank you so much for always watching, and we are again here to serve you as always. But keep subscribing. Don't watch minus subscribing. Don't watch minus liking our videos. Like, subscribe, and share to a colleague that you think may need this video. This video may be of importance to them. Right now, we want to go to Family Law 1, and we want to discuss promise to marry. Promise to marry is a common law principle that when you promise to marry someone, is some bit of contract. There is some contractual obligation that comes with promise to marry. But this one is not the other contract that we discussed, but there is a contract that you put across, and then the ideas of promissory estoppel will now come at play. That for as long as you promise to marry someone, and that someone relies on that promise, they forego what they would have been doing to do these things leading to this marriage that you have promised. So that is what we call promise to marry. There must be some kind of reliance, change of goals. Somebody changes on what they are doing to fit in the promise you have just made to them. So that's what we mean by promise to marry. You promise to marry someone. The way the word is promise to marry. So you tell someone that I want to marry you. So when such arises, the person who is complaining, that in this case the plaintiff, that there was breach of promise to marry, they must prove, one, that there was a promise to marry them, and also they must prove that they relied on that promise. The moment that is proved, and then the rest is evidence, circumstantial evidence, that will come along with proving that yes, there was a promise to marry. So that person must prove that there was a promise, and that promise has been breached by the defendant. Now, let's look at the elements of promise to marry. That one of the elements of promise to marry is that there must be a promise. That someone must come and promise you that naturally, yeah, I want to marry you if you do this. Or Nachidija comes and tells me, if you pay for my tuition, I promise I'll marry you after my studies. So when there must be a promise, so you must prove that yes, indeed, there was a promise. So after you have proved there was a promise, then there must be reliance. that when you promised to marry someone, I relied, if naturally just said that they will marry me if I pay for their tuition after school. So, and they don't do the same. So I must show that I relied on what they did, they said. It's very important. Reliance. I must show that I relied on what they promised me. Then after I have proved that, colleagues, then there must be a breach. They must have breached. They must have refused to comply to it. In the event you don't prove that a promise was breached, then there was no breach of promise to marry. Then you cannot institute a suit against that person. Let's now try to broaden this. What happens if there is a breach of promise to marry? There are two things. One, you can let the person be. You go your ways, they go their way. That is the. Two, you instigate a suit for the breach of promise to marry. You go to court and you institute a suit that there was a promise to marry which I relied on and so breached this promise. So I want to be compensated. Definitely. When you prove the ingredients, you get damages. So, promise to marry being a common law principle, it has now evolved. At common law, there were no remedies for it. But now it has evolved to the extent that now there are remedies. The moment you breach a promise to marry, there will be remedies awarded to that person if they satisfy court that indeed there was a promise to marry. But again, there are instances when the breach of promise to marry will not succeed or will not stand. Let's now discuss the instances when it will not stand. Of course, number one is death. If I promise to marry you and I die, definitely I die with the promise to marry. You may not be able to succeed. Then, when I become of unsound mind, I promise you, but along the way, I run mad. So at that particular time, you may not be able to succeed. Now those can act as defenses. Then when we have said when you unsound mind, when there is death, when there is an agreement, we may agree to end it. I agree with you that this has ended. Yes, I promise. But if we come to an agreement, you and me, to end this, then automatically that means that we have ended the promise to marry that I had made. Then there are instances where promise to marry will succeed. If your colleague, your partner, misrepresents himself, if he tells you that I am ABCD, but then you find out there is that bit of misrepresentation. When there is misrepresentation, you will go to courts of law and you will succeed because this person has misrepresented himself. If there are instances of fraud, where we have fraud, you can ably succeed in terms of discussing promise to marry. Where there is change of religion, change of religion, I think, works the other way. Works on the first instance that where promise of marriage may not succeed. Because if I change religion, it is personal. It is personal. And then you are in the other religion. So you would say yourself that, and now that you have changed religion, I cannot really do this. Meaning that you who has promised to marry, you have accepted. It's like agreement that no, you have changed your religion. And then those are some of the areas where you can ably succeed. The conduct of the other party. If the party who promised is conducting themselves in a funny way, then that means you can ably succeed if you lodge a suit in terms of a breach of promise to marry. Now, promise to marry has been elaborated more in cases. And now I want us to go through these cases, and then we see how promise to marry has been elaborated. The locus case we have for promise to marry is Larok versus Obwoya. In Larok versus Obwoya, Obwoya promised to marry this girl. She was very young in school. She even got pregnant. And later, because first she relied on a promise, later he says, I'm not going to marry you. So the girl goes to court and she succeeds. Court held that we are giving the girl a lot of damages because of the breach of promise to marry caused her emotional disgrace, emotional distress, that she was emotionally affected. And that was the ground for awarding her damages. Let's look at the case of Tumwine Richard versus Kyarikunda Fortunate. Kyarikunda promised Tumwine that pay for me my tuition for LDC, diploma in law, after I'll get married to you. Tumwine did the same. But after, Fortunate reminded him as he was an old man. He couldn't marry him. So he went to court, and court says that because Tumwine had presented receipts of tuition he had paid and all the evidence around, so therefore the Kyarikunda had to pay him damages of worth 9 million. We are told up to now Kyarikunda is still paying the money. Look at the case of Shaw versus Shaw. Look at the case of Fender versus mildmay. All these are cases of federal government discussing public policy. What happens if there is a public policy and then promise to marry? Okay. Now, look at all these cases and you appreciate the concept of promise to marry. But never discuss it when I discuss the case of Larok versus Obwoya. So I urge you to go and read these cases. But that is the concept of promise to marry, brief as it is. So we thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, and always like our videos. Thank you.